Welcome, everybody. This is Alan Gassman, and I'm here with my friend and colleague Lester Perling. And we are so pleased to have you for this edition of Florida Health Law Traps, five hypotheticals and discussion of important medical structuring and regulatory issues. Lester, how are you doing this afternoon?
I'm doing good, Alan. How are you?
I'm doing great. Looking forward to hearing your presentation. Before we start, I just want to mention that on Monday, February 25th, Lester and Jeff Howard and I are going to be presenting Medicare and Medical Compliance Disasters, What to Do Before and After the Explosion. That's going to be half an hour, Monday, February 25th. Also on our website, you can see the webinar we gave Tuesday, February the 5th, Estate Planning for 2013 Beyond the Obvious, and one that I gave February 11th, that was last week, the Physician's Guide to the 2013 Tax Laws, which was half an hour. You can go to the Gassman Law website and just click on webinars, and then it'll just start playing whether you want it to play or not. Also, Lester and I have written a book on kickback and self-referral laws for Florida physicians, and you can get that on Amazon or send us an email if you want a special discount. And also there's one for creditor protection on Florida physicians on Amazon. And a couple of other books we've written on advertising and the controlled substance laws. Lester, I'm going to let you go ahead and take it away with hypothetical number one.
All right, Alan. Hypothetical number one is you're a client, and this is written assuming I'm speaking to lawyers, but you can substitute yourself in there. Your client is the administrator of a group practice. The practice has decided that because of the administrative burden and costs associated with collections, it would just waive co-payments and deductibles for insured patients, but continue to charge the insurer the usual and customary rate for that practice. In addition, the practice is establishing a prompt payment discount for patients that fulfill their cost-sharing obligations at the time of service. This discount would be applied contemporaneously to the services provided to the patient. So this is really, this hypothetical is essentially about waiving and or discounting co-payments and deductibles. Alan, are you doing the slides?
Yeah.
Or? Okay, go ahead.
Page 8.
Thank you. The key point with the waiver, one of the key points with the waiver of co-payments and deductibles under Florida law is that it can in fact be considered insurance fraud unless that waiver is disclosed to the insurance company at the time the claim is submitted to the insurance company. Florida calls this a pre-provision of services agreement. So what this would be is patient comes in, the provider says to the patient, particularly this happens more than not with out-of-network providers, but not exclusively, says to the patient, look, I know, you've got more out-of-pocket, don't worry about it. You only have to pay 20% of your out-of-pocket or 50% or zero, and I'll accept what the insurance pays me for the balance. Under Florida law, that's a pre-provision of services agreement, and it was done, as the name implies, prior to the service being rendered. It's not, at least for purposes of this regulatory scheme, per se illegal. However, to the extent that that is not disclosed to the insurance company, it's considered, as noted here on this slide under Florida law, insurance fraud. So it can be, it's a criminal statute. And so engaging in that practice is not a benign behavior. Now you note in the second bullet point that you basically can reverse the presumption that it's fraud if the agreement is disclosed on the claim or on the bill, so that the insurance company knows that the provider has entered into the agreement. And I think, Alan, on the next slide, it talks about the fact that there needs to be specific disclosure with regard to the terms of the agreement. And the reason for that is because they want the insurance companies to be able to reduce what they would otherwise pay the provider. So, for example, the fee's $100. The patient has a 20% copayment responsibility that the provider has agreed to waive prior to the delivery of the service. In the normal course of events, the insurance company would pay $80. If that waiver of the copayment is disclosed at the time the claim is submitted, the insurance company would have the opportunity to reduce that payment from $80 to $60, thereby basically accounting for the fact that the physician's fee is essentially not really what he's claiming it to be because of the waiver of the copayment. And that's actually playing out now real time with a client of mine. I'm currently dealing with United Healthcare, who believes, based on interviews of insureds, that the provider has been routinely waiving 40% copayments and deductibles. And they are now demanding a refund of a significant amount of what they've paid the provider, essentially 40%, based on the provider's failure to disclose this to them. And this is the first example I've seen of an insurance company actually seeking to get money back based on this theory. So,
how did they find out about it?
There were some billing issues with the provider, and as a result, they started interviewing their covered insureds. And in the process of interviewing them, that's one of the things they I'm not sure if they heard affirmatively from the insureds or if they decided to ask them about it. It didn't come up in isolation. It came up in the context of a billing issue. But nonetheless, now the provider is having to deal with that issue in addition to the billing issue. And I think this is going to become more prevalent because, as the United lawyer told me today, she said, look, this is, these disincentives, particularly for the higher out-of-network copayments, are there to discourage utilization, unnecessary, she put it, utilization, and to encourage people to stay in network. And I think the insurance companies are going to start getting far more serious about this as more and more providers are trying to entice out-of-network patients because, frankly, they pay better than in-network. So it's going to become a little bit of a battle of wills, if you will.
Wow.
Between the insurers and the providers. Additionally, that type of routine waiver can be considered a kickback under potentially state or federal law, again, particularly if it's offered before the service is rendered as an inducement. So let's say I'm a patient and I got to have an MRI done, and I call Frank's MRI Center to schedule it because I saw a nice ad in the Yellow Pages. And I say, oh, by the way, Frank, are you a United in-network provider? And Frank says, no, I'm not a United in-network provider, but don't worry, you won't have to pay me the additional copayment. You'll only have to pay what you would have paid an in-network provider. Well, I think there's a really good argument that under Florida law, that would be considered an unlawful inducement under the Florida Patient Brokering Act, because essentially it's offering something by Frank to me as a potential patient to induce me to patronize his MRI center. Similarly, if I'm a Medicare beneficiary and Frank says, oh, don't worry, I won't make you pay your copayment if you use my MRI center, that's likely going to be considered both as a potential inducement to the beneficiary as possibly also as a kickback to the beneficiary. So it really has a lot of implications associated with it. It's becoming a more common practice, and I think it's going to be the subject of more scrutiny.
So basically, don't waive copays unless you're really careful about it. And with private
insurance company.
Tell the insurance company. And do you have any clients that are actually telling the insurance company? I imagine the insurance company ignores the notice. Okay.
I do. They ignore the notice, but that's okay if it goes in with the claim. The fact that they ignore it, it becomes to some degree their problem. Now, that does not cure an allegation of an unlawful kickback under state or federal law, though. That only addresses the insurance fraud issue potentially. So,
but then waiving the copay for Medicare is not going to be safe, or Medicaid.
Correct, or for private pay under the Florida Patient Brokering Act potentially.
And then when the patient can't afford it, you let them in, you let them see the doctor, you send them a bill, and then you have somebody verify that they can't afford it, right?
Right. What I'm talking about here is primarily where this is agreed to before the service is rendered.
Right.
Although if there's a routine waiver that isn't agreed to, it could still be an issue from a kickback perspective. But certainly where the patient is has financial hardship and that's documented, the patient signs a financial hardship statement, or a provider does make an attempt to collect and writes it off. There's really no obligation to sue every patient that doesn't pay, but a reasonable collection effort is expected under the circumstances, which might vary patient to patient.
Okay, well, can't be too careful here. Should we go to the next hypothetical?
All right.
Okay, by the way, if you have any questions at all, you can just email Alan, A-L-A-N, at gassmanpa.com, or if you have Lester's email address, you're welcome to, it's lperling at broadandcassel.com, and we're looking at emails during the presentation, so we'll be glad to answer your questions. Okay, hypothetical number 2, your client is a solo physician practice. A police officer comes to the practice and asks questions about the treatment provided to a particular patient. The officer explains that he's conducting a preliminary investigation involving that patient and explains that he needs to know what medication the physician has prescribed to the patient. The police officer doesn't have a court order or subpoena for the medical records, but he's got a badge. How should you advise the physician to respond to the police officer's request? I mean, I was raised to always respond to police officers' requests.
Well, they are the ones with the gun, not you.
Right.
This is not as far-fetched or as uncommon as you might think, and that's particularly, it's been probably more true in the past year or two, where law enforcement has been more actively looking at pill mills and pursuing individuals who are maybe forging prescriptions and are showing up at doctors' offices wanting information about patients. But the law is pretty clear. The badge entitles them essentially to nothing on their own. Some people think that there's a criminal exception under HIPAA, and what you see in this slide is the fact that there is one, but there has to be a court order, a warrant, a subpoena, a grand jury subpoena, an administrative summons, civil investigative demand. It isn't a carte blanche for law enforcement of any type, whether it's FBI, local police, whoever they may be, to come in and either get records or information. And keep in mind, it isn't just records. This is about disclosure of information as well as records. It applies to the same extent. It can be hard to say no, but that's what's required absent the appropriate legal document giving them the actual authority to get the information or to get the records. And even then, it's not unlimited in scope. They can't just, they have to have, either has to be redacted or they have to have a special reason, a specific reason for wanting unredacted records. And Florida law has similar restrictions, Alan, if you flip to the next slide. Mm-hmm. Here you'll see the Florida statute, again, court order or subpoena. And there has to be notice to the patient or the patient's legal representative under Florida law.
Oh.
And now search warrants, of course, probably are enforceable. And I certainly wouldn't try to stop law enforcement if they're at someone's office with a search warrant from taking the records. I think, if there's a question about their authority to do so, you're better off dealing with it later, because law enforcement officers executing a search warrant have very little sense of humor. It's best to not get too aggressive or interfere with them. That doesn't mean you can't then file something in court at a later date. If there's mental health records or substance abuse records involved, then there's even tighter restrictions, as you see on these slides. And again, I mean, a little war story. I had a few years ago the head of the Secret Service office in Miami call a psychiatrist client of mine wanting some information about a known threat to the president who was coming to town shortly thereafter.
Wow.
And somehow the Secret Service got wind of the fact that he was being treated by my client, which in fact was. The client properly referred him to me. I had a nice chat with the Secret Service agent where he was telling me that it's a matter of national security, et cetera, et cetera. And I said, well, that's great. You give me a statute that authorizes this release of information, and then we'll talk about it, which, of course, he couldn't do. And so at the end of the day, we, despite his significant protests, we did not give him any information. And so it can be difficult, but you have to stand firm because there can be significant liabilities. I think what they did in that case was they found the guy. They knew where he was. They just found him and threw him in jail for the day or something like that, and let him out at the end of the day. That might have been a violation of his civil rights, but in any event, that wasn't my client's problem at that point. So,
of course, all clients need to know that when the government shows up at their office or an agency reviewing charts for Medicare, to call the lawyer and not to just let the agency do what they say they want to do right away. Right.
Yeah.
What do you tell clients when they call you? What do you tell clients when they call you and they say, hey, the government's in my lobby, what do I do?
I say put them on the phone.
Right,
and then
exactly.
I talk to whoever's there and see what they want and negotiate something within what their rights are. Because again, any government agency, whether it's a Medicare contractor or law enforcement or you name it, have very limited rights to come in and barge into your place of business and look at records or interview people absent a search warrant. And it's an intimidating situation, which is why it's best to let your lawyer handle it, because the lawyer doesn't have the same emotions at play and fear for their business. It can deal with it more directly with the government agent. But it's surprising how reasonable the government agents will be once they get on the phone with the lawyer and they quit trying to intimidate the provider.
Right. And also we tell the clients, and we also tell the clients, don't talk to them. Have your office manager talk to them, your receptionist talk to them, but don't talk to them.
Or no one talk to them.
Because otherwise they'll just misquote what you said. So you want your lawyer there when you talk to anybody who's doing an investigation, because you don't want to be misquoted. So, okay, very good. Shall we go to hypothetical number 3?
All right.
Okay. You represent a physician practice that's enrolled in the Medicare and Medicaid programs. During a routine internal audit, the practice's billing manager discovered that certain claims submitted to and reimbursed by Medicare and Medicaid programs were upcoded. The billing manager brings this error to your attention. What are the practice's obligations under state and federal law? Well, Lester, first tell us what the technical definition would be of upcoding.
Billing for a higher level service that's probably compensated at a higher level than the service that was either provided or at least that the documentation reflects was provided. So for example, the patient has a single view chest x-ray done, but 2 views are billed. The patient has a low-level office visit or evaluation and management service done, but a higher-level office visit is billed, and that's probably the most common example. So that, an office visit has 5 levels. And so let's say the documentation would support a level 2 visit, which is the next to the lowest, but what was billed was a level 4 visit. And so the level 2 visit might be worth $30, and the level 4 visit might be worth $40. So that creates a $10 potential overpayment. So
and this must accidentally happen all over the place, right?
It does, of course. Yep. And sometimes not accidentally, but 99% of the time it's either accidental or, as the government might say, due to deliberate ignorance. Accident now is generally not an excuse anybody will accept. Rarely, a lot of these things. There's providers are presumed to have a certain level of knowledge, and if they don't have it, it's termed as deliberate ignorance for purpose of the False Claims Act. So
okay. So do we just fire the billing manager?
Probably not, because then what you've created is a whistleblower.
Right.
And it probably, at least under my hypothetical, is not the billing manager's fault. It's probably the physician who documented the visit and completed the super bill, which was used to submit the ultimate claim to the Medicare program or the Medicaid program. The appropriate reaction is to think about what your relatively new obligations are for disclosure under federal law. So, Alan, if you could.
Yep, there we are.
And here we have it. One of the things the Affordable Care Act did, besides creating health exchanges and all the other things that everyone is so excited about, is it explicitly said that if a provider receives an overpayment and has a known overpayment, so known is a key word, we'll talk about that in a minute, but there's a known overpayment, the provider does not report and return the overpayment within 60 days of the discovery, under most circumstances, then the failure to disclose and return the money itself becomes a false claim. So let's say, for example, we'll go with Alan's. It was a completely accidental error. It wasn't due to ignorance. It was keystrokes. Whoever was inputting the stuff into the computer kept one day repeatedly hitting the wrong key. And she was hitting 2 instead of 3, or 3 instead of 2, rather. Purely an accident. However, the practice discovers it and says, it was an accident, let's not worry about it. If they ever find out about it, we'll pay the money back. So 90 days go by, or 61 days go by, and nothing's done. And someone in the practice who knows about it says, oh, gee, I'm going to make a little money, and files a suit under the United States False Claims Act. Well, while the claim submission itself may not have been a false claim, because the facts would show it was a really innocent accident and keystroke error, that failure to disclose the overpayment is a false claim. And therefore, there would be liability on the part of the practice for triple the amount of the damages and a $15,000 per claim penalty and potential exclusion of the provider. So the failure to disclose, while it's always been an issue, and the failure to return an overpayment carried potential penalties before, it was always somewhat unclear. Well, now it's very clear that there are penalties involved, and obviously very significant potential penalties. So it's another potential banana for whistleblowers out there. When practices or providers ignore this affirmative obligation to disclose Medicare. There's a couple questions.
Okay.
Go ahead, Alan.
I'm sorry, go ahead. I didn't mean to interrupt you.
Oh, good. One of the questions is, well, when do I know there's an overpayment? Well, in some circumstances, you realize that, gee, the wrongs were submitted, and they were done for 23 specific claims, and that's it. Okay. When you've identified that, the 60-day clock starts running. But suppose that you think you have an overpayment, but it's going to require auditing. Does the 60 days start running when you think you've been overpaid, or does it start running when you complete the audit and determine that, in fact, you were overpaid? Arguably, in that circumstance, it's when you complete the audit. What about if I do an audit and I look at 10 claims, and I see that out of the 10 claims, a sample, 6 of them were overpaid, but I don't look at any additional claims beyond those 10 claims, even though I have reason to believe that all the other claims of those type, 60% of those may have been overpaid as well. That's unclear under the statute. under proposed rules that Medicare issued, that would be, you would have an obligation to look further, and you would be deemed to know you were overpaid at that point when you chose not to look further, because again, you sort of became deliberately ignorant. Now those are proposed rules, and we don't know what's going to come out in final rules, and we don't know, how the courts are going to interpret this particular statute. I'm sure we'll get more information on that point as the years go by and these cases get litigated. But it's certainly another significant potential threat if providers ignore these things. They do so now at very much at their own risk.
Now, is this only Medicare and Medicaid money, or would this apply to upcoding HMO risk contract?
Well, anything
matters.
If it's not a Medicare, if it's a private plan, none of this applies to private payers.
Okay.
It's only where government money is involved.
But I would think government money is involved in a Medicare HMO.
It is, yes, but
wow.
Not in a commercial HMO or an ERISA plan. There, it's up to the private payer to seek recovery if they think there's an overpayment. And, under those same set of facts, they could argue a civil theft, because if you know you have an obligation and you ignore it, and particularly if they demand under Florida law that they send the right demand and you ignore it, it can become civil theft at that point with similar trouble damages to the False Claims Act, although that's much less likely to happen.
So you really, as soon as this is brought to your attention, that you want to hire a lawyer who hires a consultant, comes in under attorney-client privilege, and does an immediate investigation of what you've got and what you're going to do with it, right?
You really, that's the appropriate course of action, yes.
Now, if you don't do this and that billing manager becomes a whistleblower, what do they stand to gain?
30% or more of the recovery by the government under the False Claims Act. So.
Oh my gosh, that's better than the lottery.
The odds are probably better, certainly.
Yeah. So we go to Florida law now?
It does. There, as you see, that Florida law also requires that providers ensure claims are accurate, and it's a sanctionable violation to not disclose an overpayment and refund the money. And under this Florida law, it's 90 days of receipt. And also the Medicaid provider agreement has a requirement for refunding overpayments, so that the provider could find themselves being booted out of the Medicaid program for failing to do so as well. So.
Oh my gosh. This has really become very serious stuff, hasn't it?
The government's very serious about getting their money back, yes.
Yeah, and doing the coding right is essential too, that's for sure. Okay. Now, what about somebody who buys a medical practice and gets a new ID number? Do they have responsibility for the prior owner? If the prior owner was not coding right at the same location?
If someone buys the assets, let's say, of a medical practice, and so it's a new corporate entity, a new Medicare number, et cetera, then no, there wouldn't be successor liability. Now, on the other hand, if the provider themselves, in an effort to avoid their obligations, shuts down one practice and moves their practice into a new corporate entity, then I think they would be very much at risk for successor liability, but not in a legitimate sale. That being said, if it's a stock sale and the claims were submitted under the corporate Medicare number, the group number, that liability stays with the company.
Wow. If you were stock sales.
The new owner may not have personal liability because they were involved in the decision not to disclose the overpayment and refund the money, but there still would be corporate liability.
Okay. Now, before we go to the last two hypotheticals with 15 minutes left, there were a couple of questions, and I'm sorry I didn't notice them before. The first one was, does waiving copays apply to employees of the practice? Can you give your employees a special break? I'm guessing the answer is no, unless you notify the carrier that you're doing it.
Yeah, there's really no exception under those laws for employees. Now, I think as a practical matter, a third-party payer or private carrier might not be so harsh about it because it's going to be a very limited, well, in most circumstances, a limited number of people involved. But technically, the same rules apply. There are no exceptions for employees.
Okay, then another question, will the PowerPoint be available? Yes, if you did not receive the PowerPoint by email, if you send us an email, we'll resend it to you. Because everybody should have received, besides seeing it on the screen in front of you, everybody should have received the PowerPoint, and you definitely want to have that because it has Lester's picture on it. Okay, then the third question, it says on the HIPAA and Florida law on confidentiality, what do you do when a patient puts a complaint on a website and can you put a comment on it when the patient's revealed themselves? And also, what about when a plaintiff lawyer holds a pre-litigation press conference to discuss a case, and the doctor can't really say anything because of all this confidentiality law, right? So the doctor kind of has one hand tied behind her back.
Well, the issue becomes, let's do the first one first. Let's say the patient goes on Yelp or whatever and says, I went to see Dr. Fred Smith yesterday, and Fred Smith happens to be a psychiatrist, and, he's a quack and blah, 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 says all these kinds of things. Well, the patient obviously has disclosed that himself, which the patient can do. The patient can disclose whatever they want of themselves. But does that give the provider the right to defend themselves in that context? And, there's nothing clear. There's no clear guidance out there on that issue when it comes to the internet. But my advice to providers in that circumstance is leave it alone, because number one, it only will wrap things up as a practical matter. Because if you go on, if you make some contrary comment, it's probably going to incite the patient to keep it going. The other thing is again, you're the psychiatrist who's been criticized in Yelp, then you have, by going on the website, depending on what you say, you may have confirmed that this person was your patient, and you really can't do that. So the better part of valor is to leave it alone. I have had clients in that situation where what was written was something more than an opinion and probably defamatory. And we have sent cease and desist letters. We demanded of people like Yelp and Yahoo that they take posts down, which they will sometimes do if it appears like they might be getting themselves in trouble, which is all done, privately, not in the public domain. On the other hand, when a patient sues a doctor for malpractice, then they have put their medical condition at issue in the public record, and it frees the physician up to release information about that patient. Whether I would do it in a press conference is a different story, but technically the patient, once they've sued in that situation and disclosed all of their medical information themselves in the public record, the physician's allowed to defend himself and similarly disclose information about the patient.
Now, another question I got by email from Debbie is, if a provider does disclose the information, say to the police officer, and wasn't supposed to, is there any sort of cause of action against the doctor for violating the privacy laws? Debbie's thinking that there's no private right of action under HIPAA.
There is not a private right of action under HIPAA. The patient really has limited remedy in that situation. There are private rights of action that the patient may have. The issue is what the damages would be, and absent it being HIV related or a couple of other circumstances, the damages may be limited. However, that's not going to stop the Board of Medicine from disciplining the provider. Because certainly the patient can complain to the licensing board, whichever one is appropriate, about the improper release of information. And most of those boards take that type of complaint seriously, because I've certainly seen physicians be disciplined for the unauthorized release of information. But if they can show damages, for example, loss of a job, then certainly there are causes of action that they can use, negligence and other to potentially recover those damages.
Okay.
You're correct. There is not a private cause of action per se under HIPAA itself, but there are state law claims that can be made.
Okay, great. So with 9 minutes left, let's go to the second to last hypothetical. You represent a hospital that has a lease rental arrangement with an orthopedic physician's practice. Under the arrangement, the physician pays the hospital fair market value monthly rent to lease the office space. But the rental agreement expired 8 months ago. The physician has still continued to occupy the space and continues to pay the rent outlined in the expired agreement. What are the implications under the Stark law, I guess because you don't have a one-year lease anymore?
Correct. The Stark law, as Alan mentioned, would require a written one-year lease. It has, as you see here, all of the things, all of the elements listed, but we're talking now about the writing. So absent the written agreement, then the physician is prohibited from referring Medicare or Medicaid patients to the hospital in this hypothetical, could be some other type of provider. And the hospital is prohibited from billing for those services to Medicare or Medicaid. There is a provision under the Stark law, it's a holdover provision, that would allow, and Alan, if you, oh, there you go, you got it here, is allowed for up to 6 months. Now, in this scenario, it's over 6 months, so unfortunately, they can't take advantage of the holdover exception. That means the hospital has to look at the potential for refunding any money it received pursuant to this physician's referrals. The physician probably doesn't have, there's really not a direct action that anyone can take against the physician. However, the physician would be a good target in a false claims case based on the Stark violation. So the hospital would need to think about a disclosure under the Stark self-disclosure protocol to CMS. And CMS has been pretty reasonable in negotiating the potential penalty under that disclosure. And in the scenario I just described would probably not require that that the hospital refund what it was paid. It might require that the hospital refund to the Medicare program the amount of rent it received during that period or something like that. So they've been pretty reasonable. However, if a whistleblower gets hold of it, the whistleblower and under the False Claims Act, there's no such reasonableness. Ooh. And that would be the basis for a whistleblower suit.
Oh my gosh.
So it really behooves providers to pay attention to their contracts. I just spoke to a very large hospital chain client who won't be named this afternoon about this very issue because a lease had expired with a group of physicians over 6 months ago, or it was about to be 6 months. So this is a common scenario and can lead to some truly disproportionate consequences if not handled properly.
Right, right. Okay. Let's go to the next page. Anything else you want to mention there, or should we go to the next hypothetical?
We can plow ahead. I know time's running short.
Okay, the last hypothetical. Your client is a physician practicing with a group practice. His or her first cousin is a minority owner of a home health agency. Your client and the other physicians in the group refer patients to the cousin's home health agency because it provides the best care. In addition, your client's wife is a specialty physician who owns an independent practice to which your client and the other physicians in the group refer patients. Are these referrals problematic under state and federal law?
Well, the answer to the first one regarding the cousin is simple. It's not, because although immediate family members' ownership is attributable to the physician, a cousin is not an immediate family member.
Okay.
The wife, however, is and poses a more significant problem under both the Stark law and Florida law. If, let's say the husband is a primary care doc of some sort and he practices in a group with some other guys on their own. The wife is a cardiologist. She has her own practice, and she does ultrasounds or echoes, and she does nuclear medicine. The husband cannot refer to her practice. under state or federal law. There's no exception that would apply. The other doctors in the group could, absent the husband doing something to manipulate that, but presuming the husband didn't. But the husband can't refer, even if the wife is just practicing medicine. She doesn't have any other ancillary or imaging services. Under the Florida Patient Self-Referral Act, the husband cannot refer to the wife's practice even for a consult because he has an ownership interest through attribution from his wife, and there's not an exception that applies. And that's a thing. I think that happens pretty commonly, where husband and wife are in for practices, and that may be because folks like Alan, who are trying to do good asset protection, say, well, don't practice together, keep it separate. But unlike Alan, they're not aware of this problem and therefore create a Self-Referral Act problem by worrying about the liability issue. So there's definitely some potential problems in that kind of referral pattern. One thing I want to mention that is a little bit similar, because it involves doctors' wives, is it's become somewhat common in Florida for home health agencies and sometimes some other types of providers to employ physician wives as marketing representatives or other types of jobs, which is not automatically illegal just because they're the physician's wife, but the government is starting to pursue those relationships under a kickback theory that the only reason the wife, or it can be a daughter or whatever, of the physician is employed is to induce that physician to refer patients. And there are some successful cases that are moving ahead in Florida of that ilk, and where the provider is getting potentially prosecuted, but the physician and their wives could be prosecuted as well. And that's a fairly recent, the government's just caught on to that. It's been going on for a while, but suddenly it's become the focus of some government attention. So.
Wow. So get divorced if you're going to refer to your spouse. Maybe your spouse could marry your cousin or something like that.
There you go.
That could be good tax planning, too. Okay. Had another...
Sounds like a new book, Alan. Sorry.
It sounds like a new book, exactly. 67 Reasons to Get Divorced. Okay. One question is on the refund, the 60-day refund rule. What if the mistake is by Medicare or Medicaid? They made the mistake and they overpaid. It doesn't matter? Oh, my gosh.
Doesn't matter.
Wow.
I mean, it won't be. It's not a false claim because obviously you didn't submit a false claim, but you discovered that Medicare paid you $500,000 too much money. 60 days from that date, if you don't return it, the retention of that money becomes a false claim.
Wow. Wow.
It's kind of like if the bank, accidentally puts $1 billion in your account, that doesn't become your money. And so it's the same theory.
So then one last question is, if a prescription was for a narcotic created by a patient, created by a patient, can the physician turn that over to the police because the patient has committed a crime by forging the physician's prescription?
Yeah, yes.
Okay. Yeah, that's a very good question. Okay, well, Lester, go ahead.
No, I'm done.
Okay. All right, let me just mention for those, I know a lot of healthcare lawyers and other lawyers are on this call. The Florida Bar Advanced Health Law Topics Certification Review Course, which is an excellent course, is going to be Friday, March 8th and Saturday, March 9th. And I'll be speaking on healthcare tax issues. Lester's partner, Mike Siegel, will be talking on regulation and relationships. Sandra Goldblatt, who's on this call, will be talking on restrictions on anti-kickbacks, fee splitting, patient brokering, and self-referral. And Lester will be talking about federal anti-kickback prohibitions and self-referral. Those are all on Saturday, and then Friday there's a lot of good. If anyone wants information on that seminar, which will be in Orlando, let us know. We'll be glad to send it to you. If you have any questions, just go ahead and email them. You will be able to watch replays on our website beginning tomorrow, Janine willing. Just go to the Gassman Law Associates website, and you'll hopefully see this come up, and you can click on it and watch it. Don't forget to tune in with us February 25th with Jeff Howard for Medicare and Medicaid compliance disasters, what to do before and after the explosion. Please buy 100. If you buy 100 of these books, you will get 100 free. So page 28, you can just email us if you want a discount on these books. We'll give you the special code, and you can put that on Amazon. And thank you very much for attending. Have a fantastic evening. Thanks, Lester.